Thanks, Varun, and welcome everyone. Good morning. And hello, I'm Ashish Agrawal. I lead the public policy work at nasscom. I have my colleague Varun here, who is our expert on data protection law, and Priyanshi, who is also the expert on data protection. And then we have our external experts. And at least with Nikhil, we have had a long engagement in this journey of leading up to this law getting enacted. And Nikhil Narendran, he's a partner at Trilegal, based out of Bangalore, is the technology, media, and telecom practice partner. And Shivangi is a new addition to our conversation on data protection, but Shivangi Nadkarni, she is CEO and co-founder of Arrka. And I think what probably is a little bit of difference between the lens which Nikhil and Shivangi brings in is that Shivangi has also a bit of industry experience and probably looking at from the tech side of implementation also. And for us, this is first of the webinars which we are conducting. So a lot of questions which we may not get answered here are questions that we'll be compiling. It's an opportunity for all of you to keep on engaging with us. I would request Varun or Priyanshi to put in an email of our policy team so that you can contact us and we can build out this conversation. From a nasscom perspective, this is about bringing industry on a platform, getting some real concrete advice on the table, and also then get some takeaways which you potentially can feed into our conversation with the government. So with that, I quickly hand it over to Varun because I think we have a lot to discuss. Varun, over to you.
So thanks, Ashish. And after that context, I just want to take a minute to just lay out how the conversation will work. So we're first going to have a presentation by Nikhil for about 15 minutes, and then we'll have an open discussion starting with some opening remarks from Shivangi from an implementation perspective. So just to echo what Ashish said, our lens has been to look at the Data Protection Act from certain business functions or from certain segments where we know that it's of relevance to our members. So during our registration form, we did get quite a wide variety of questions on the Act. We're going to be trying to stick to the domains of marketing and advertising and related processes for industry in this presentation. But in future webinars, there will be opportunities for questions such as those on HR and employment to get their own dedicated attention as well. So please don't worry if, like, as in some of the questions that you do have don't get answered here, because we will be taking care of that. On that, I'm just going to hand over to Nikhil to start the presentation that he's prepared for us on the law. Over to you, Nikhil.
Thank you, Varun. Thank you, Ashish. Special thanks to nasscom. It's been a fantastic journey. Over many years, we've been talking about the Act, different forms and versions of the Act. Just before we starting the webinar, we were just having an internal chat that, look, now the conversation is different. And it's we all we're sort of waiting for this difference probably to happen. In any event, our focus today is on advertising and marketing. And here also, look, advertising and marketing is fairly a broad subject, right? It's possible to go down a rabbit hole when it comes to aspects relating to advertising or marketing. There are newer technologies coming up with respect to containers and data lakes and dipping and enrichment and various others. So we'll stick to the basic concepts and basic contours of marketing and advertising for the purpose of this session. But in any event, if you have a further question, and just to let you know, the basics remains the same, right? It's just that when we implement some of these technologies, the way in which that technology interacts or the interface with the user per se may bring in some differences, but frankly, the basics of the law and the compliances remain the same. The lens that we may look at the compliance may be slightly different depending on the actual technology that's put in place. So with this, let me briefly talk about advertising. The way it applies to advertising is the way Act applies to is that if there is some sort of advertisement activity which is conducted using personal data. So if you are used to the offline way of advertising, obviously the Act doesn't apply to you. But if you are doing any digital form of advertising, and the digital form of advertising need not just be online in the pure form of web or apps, it could also work in the form of any sort of directed advertising at any form. Whether it's by way of tickers, whether it's by way of emails, whether it's by way of telemarketing, whether it's by way of any other form of reaching out to the customers, and even, if the collection per se is using some sort of cookies, third-party cookies, other forms of device identifiers, etc., the act could apply to such instances of advertising and marketing. Just to keep in mind when we talk about this as well is that, look, there are the good thing about the act, probably it's slightly narrower when it comes to a statute like GDPR, when it comes to the definition of personal data. So given the narrowness, a pure device identifier, for instance, a pure MAC ID or a pure IP address, need not always amount to a personal data under the ambit of the act. So unless you have other details with respect to the user, for instance, if you have a user's name and an IP address, it is covered under the act. If you do not have the user name, but just the IP address, there is a potential that, or a possibility, depending on the actual technology and the other data sets that you have, that the act may not apply to you. So in that sense, it's narrower, which is a good thing. But if you have these details and then you engage in the activities of targeted advertising, email marketing, user tracking and profiling, etc., the act will apply to those forms of advertising. The other aspect to keep in mind is, look, it does not, however, apply to publicly available data. So for instance, if you're processing someone's publicly available information to reach out to that person, and in those instances where that particular publicly available data has been made available by that person, for instance, I am publishing on Trilegal website my mobile number and my email ID. And if you reach out to me using that mobile number or email ID, since I am the one who made that data available in the first place, I cannot claim protection under DPDP, and you don't need to necessarily comply with the provisions of the DPDP Act. So that's a saving that the Act provides. But having said that, it's a very narrow construct. So you need to be very sure that it is that person who's in fact put out that data. So you cannot rely on a completely independent third-party source to reach out to a person. You cannot entirely rely on a directory which lists public information and reach out to that person and say that the act does not apply to those instances. So those are the few nuances that will come into play when you look at advertising and marketing using the act. Email and telemarketing is something which, like I already mentioned, it applies. The same sort of exception applies in terms of publicly available data. So the data that's used to contact principals, so whether it's an email, whether it's name, whether it's SMS, if you're contacting, or even for that matter, WhatsApp marketing, which is fairly common these days, if you contact a person, then the act will apply. I will obviously talk about the instances where which you can use or contact a person and the ways in which you can use it in the next slides coming up. So if you also use data to sort of customize telemarketing, so purchase information, resume information, user investment detail, etc. So these services are typically provided using telemarketing. Even those sort of ambits and those sort of services will also be covered under the ambit of the act. There are two basic ways in which you can process data under the act. So one is basically a consent base, which is a classic use case that you find. You reach out to a person before you email someone, before you contact someone, you get a consent. That consent often is difficult. So there is another way in which the act enables using of data without actually taking the consent. And it is basically a legitimate use as a basis of processing information. And one of the bases in which you can use it is if a person voluntarily provides the data. For instance, if I am going to a website and signing up to, there is a column which says that, look, do you want our newsletters? Then give me your email ID. And I go there and fill in my email ID. I am voluntarily providing that information to you as a company or an entity which is doing email marketing. And you are free to email me for the specific information that I have sought for. So the way it typically works, way it always worked is, at least in practice, most companies used to just give this and then randomly used to send all sorts of newsletters, sometimes marketing emails, advertising emails, etc. That cannot work. It needs to be specifically for a specified purpose based on the interaction. So for instance, you can take a person's email with the purpose that, look, I will send you newsletters. Are you interested in getting our newsletters? I can give my email ID and you can send emails to my email ID. But you cannot then use it for advertising purposes, and you cannot say that, hey, I have some offers for you. Are you interested? That cannot be the purpose. So On the other hand, if you have another column in at the time you subscribe to the email itself saying that, hey, you also want to subscribe to specific market, which is a specified use, and give your email for that purpose, you can also send emails for promotions and other offers, etc. And you should always give the option to the other party to unsubscribe or withdraw their consent from this process. And if I go ahead and say that, I mean, it could be an unsubscribe button in the email. It could be another option in enabled on your website. If I show the option and say that, look, I no longer want to receive this email, you should respect and stop emailing me. And if you do not, then that may constitute a breach of the provisions of the Act, which could have penalties under the Act. Like I just mentioned, legitimate use can be used for newsletter emails. It can be used for transaction SMS emails. You can literally say that, hey, just give me your email. I'll send you the invoice on that. You can also provide that for online invoices. You can use that for payment links for processing a transaction. We can do limited marketing emails with unsubscribe option. These are all the various options where we can use it for providing. And even for that matter, even calls also, transaction calls also could be possible by way of, just say that, look, just give me your number. I'll go and verify you as a user, that sort of transactions, OTP messages. These are all covered under the ambit of legitimate use case, and you don't necessarily need to take consent. But this is only for, like I said, very specified use cases, very narrow use cases. But if you want to do something more, for instance, if you want to collect a person's email for sending newsletters and advertisement, and then start, tracking the user, then starts, tying up with the purchases and the invoices that he has made, and make a history of that person's interaction with you as a service provider, or have a detailed profile of that person, have more details with respect to that person's activities and nature of purchases online, etc., then you need to ultimately rely on consent as an option for using the data. So which means that if it's not a simple use case, if it's a much more broader use case, you need to necessarily take consent after providing a notice, and the notice should detail what are the various purposes for which you are collecting the personal data for, the purpose for the processing, how a user can exercise, withdraw, their rights, or give complaints, etc., etc. So these sort of specified use cases can be mentioned in the notice itself, and a specific consent can be taken from the user, provided that the consent is informed with a clear affirmative action. No longer these ticked checkboxes will no longer work. You need the user need to make an affirmative action of providing the consent, and that consent should be a meaningful consent. It cannot be a sort of an opt-out scenario. It necessarily needs to be an opt-in for a consent, and then you can use that data for marketing and advertising purposes. And also the other important thing to notice, I mean, this is a big debated question. So the notice that you provide, if let's say that you provide the notices in English, if let's say that your user is only familiar with a language like a Bengali or Tamil, you also need to enable an option to provide that notice in Bengali or Tamil. So that's another important aspect that one must keep in mind whenever we collect user data for advertising or marketing. And just to let you know, this will include emails, phone numbers, name, address, location, and various other details that you collect will all be personal data under the ambit of Act. Again, keep in mind that if you're just collecting a device identifier or an IP address without collecting any of these details, it's arguable that the Act doesn't apply, provided that you don't use that for profiling or other purpose. Also, to keep in mind that, look, large number of companies have a lot of data that they already collected. It's lying with them before the Act is in place. So the Act also puts in place a mechanism to go to the user and say that, hey, I have been using your data on consent basis before the commencement of the Act. And you should tell the user of the fact that, look, there is data that's been collected by me. And we should sort of revalidate by way of giving a notice with respect to the fact that their data has been collected and being used by us, and probably even continue to be collected or processed after the Act itself. So whoever has a database currently, any industry association, any company who has got that member database, should use this opportunity whenever the government comes up with the prescribed guidelines, go and do this one-time activity to make use of the provisions of the Act. A few things, very important things to keep in mind. We have a right to retain the data. but that retention right is only till the time that's prescribed for a specified use. For instance, if you are collecting the data for marketing purposes, right, and for newsletter purposes, and tomorrow you discontinue your newsletter service, right? At that point of time, you can no longer keep the data, unless, of course, there is some legal obligation to keep the data. You should just delete the data. It's also possible that the government may come out with a specified rule saying that, look, if you're doing it for marketing, if you're using it for advertising, or if you're a ad exchange, then this is a sort of period in which you should, retain the data for. So you should delete the data after such period of time is done, unless that data is required for, let's say, your income tax purposes, which means you can keep it for 8 years. For your, PMLA, a money laundering perspective, then 5 years. Those sort of legal, retention specified requirements will apply. Otherwise, you need to delete the data. The user also has a right to come and ask for withdrawal of consent. They can either say that, look, I'm withdrawing my consent. Do not send me newsletters again. I'm sort of and if you have my current data, delete my data. I don't want you to keep the data anymore. So we need to delete those data in those instances. And keep in mind that this will also both apply for voluntary provision use case and also for a consent-based use case also. This provision will continue to apply. And like I said, this will continue to apply for WhatsApp or any other form of advertising, even advertising that happens by pop-up ads. This rules will continue to apply. While keeping in mind, look, there is a children's data special protection that the government has given to children's data. Anyone who is under the age of 18 is treated as a child. For processing a child's data, you need parental consent, which is verifiable. So the fact that if my daughter is using the phone and sort of her data is being collected, then I should verify the fact that I am her parent should be verified by a verification mechanism, and then my consent should be taken so that my daughter can continue to use the phone and the collection of data happens in that manner is what the government is envisaged. It is particularly relevant from the perspective of advertising, especially children's advertising. We need to keep in mind that there is no tracking or behavioral monitoring of children that's allowed under the Act, which is subject to hefty penalties. There is also not possible to do targeted advertisement on children, and we cannot also do a processing that causes a detrimental effect on a child. So these are all the three broad rules while we keep in mind while we process or advertise to children. Largely, this will be relevant to a large extent from ad exchange perspectives or social media companies' perspective or gaming companies' perspective. These are the few points to keep in mind. A lot of details on how this will be implemented or what are the actual compliances required is not yet specified in the Act. So we are expecting it to come out in at least in the first set of rules that the government comes out itself is the expectation. So there we will get more details on how this would need to be complied with. Also, just keep in mind, this is not just a provision on children. It also applies to persons with Disabilities Act who are legally required to have a guardian appointed under the Persons with Disability Act. So while very quickly moving on, I mean, this is something which is not specific to advertising and marketing. But when you do advertising and marketing, what you need to understand is that you're collecting personal data, which means that there are a bunch of obligations under the Act that will apply. So we need to ensure that if we are, if you're collecting such data, we need to have a grievance officer. We have obligations to keep the data secure by way of ensuring that technical safeguards and reasonable security measures are put in place. If we have a data processor who's processing the data, we need to ensure that the data processor is bound by a contract. So you cannot keep the data beyond the point which it is required to be kept. Like I said, if you shut down your newsletter service, you need to delete the data that you collected. And also, if you are using the data for any sort of purposes to make decision, or if it's disclosed to any other data fiduciaries is involved, then we need to ensure that the data is complete or accurate. So we can, think and debate about in what situations it will apply in an advertising and marketing context. Largely, it will apply from a context of large ad exchanges rather than for simple email marketing. But we need to keep those compliances also in mind when we do these two activities. Quickly, there is a quick section on significant data fiduciaries. Largely, if you're conducting regular marketing advertising services, this should not apply to you. But having said that, if you are in the ad exchange business itself, the business of running ads and collecting huge amounts of personal data, unless you position yourself as a processor, some of the activities could also may result in a classification of significant data fiduciary, but we don't know. This is just a probable guess because volume is one of the factors that the government looks at when it comes to classification of SCF. Also, the last slide I'm moving on to, it's basically on the rights of data principals. So data principals always have the right to correction and erasure. So if you've collected data and that data, I have the right to go and seek access to it and correct this data. I can also ask for the summary of the data that's processed, the details of the processing activities that's undertaken. And if it's been shared with any third parties, I can also seek out and ask for those details to be there. Typically, there is also a right to nominate someone to exercise the digital rights when there is a death or incapacity as well. And there are a bunch of rights with respect to correction and erasure that we spoke of, right of grievance redressal, etc., which is available to a data fiduciary, a data principal. So with this, I conclude. I'm moving to the end of the presentation. Back to you, Varun.
So thanks a lot, Nikhil. That was quite comprehensive. And I just wanted to also say that obviously the act itself, we've linked a copy in the chat just now. We would recommend that everybody go back after this webinar and also take a look at the act, because there are some very useful illustrations in the act that I believe can help companies also think through what the obligations can mean for their specific use cases. Over to with that, actually, I want to come to Shivangi. Shivangi, so I think the first question that we would love to hear from you is that Nikhil's provided us with a good sense of what all the act covers, but can we hear from you about how companies should start approaching the process of migrating to the new regime, and what are the practical steps that companies could do? And maybe it would be helpful if you could pick up a practical use case on how exactly now consent would change under the new regime. And so with that, Shivangi, I'd love to hear from you.
Okay. Thanks, Varun. I was, when Ashish just introduced me, that, I don't come from the legal background, but we've kind of cut our teeth over the last decade helping organizations implement privacy, basically started with GDPR and so on. So coming specifically to what I call implementation, right? Translating into reality what compliance requires. I think first and foremost, I think all organizations need to understand that you need to implement a structured framework so that you kind of look at all aspects of what needs to be implemented, right? And there are several available. Now, coming specifically to a use case in marketing, I think it doesn't change. You first need to have do what I call a high level data map, right? You understand where data, let's say, for example, you're looking at a outbound direct marketing scenario, okay? Which could, and out when I say outbound, it could include mailers, newsletters, all that we intuitively talk about. It could include WhatsApp messages, SMSs, and so on. It could also include in-app notifications, for example, right? They are also a form of outbound messaging that goes on. Now, if you zoom out and look at them overall, you need to have a sort of a high-level data map. Understand where is the data going out, what kind of data you're collecting, what kind of messaging is going out to whom, etc. And at the back end, what is it being used for? Because for you to be able to understand all this takes time, right? The second thing is one of the first slides that Nikhil brought up is stuff like, he talked about user tracking and profiling. He talked about behavioral profiling, targeted advertising, right? Conversion to tracking and so on. I think two aspects that one needs to keep in mind over there is, first, remember that intuitively we all think of personal data largely in terms of, one is identity data, email, address, so on and so forth. Then, of course, there's, data around health or financial data, etc. But understand that especially for the marketing community, it's very important to understand that a host of personal data comes from what we call below the surface, data that comes in via app permissions. You get hold of some very sensitive data from app permissions, data that comes in from cookies and trackers. And that is what leads to all the angst that's going on the world over today, right? Stuff like behavioral profiling, etc., happens from all that below the surface data. And believe me, each of you is collecting a whole ton of it, which is all about inbound marketing. It's not really about outbound, right? So what how is that data being used? What are the third party SDKs embedded in your apps? We've come across so many instances where nobody in the company is aware of what really those SDKs are and what they're doing, and there's so much of data flowing out from that to third parties, none of which translates into the notice that is put up, right? So stuff like that you need to be aware of. Third party trackers, cookies, where are they, what are they tracking, who is the data being shared with, and then make sure you get consent, you put that up in your notice and so on. Coming specifically to consent, keep in mind that there are two parts to any kind of consent. Okay, one is the the front aspect, or rather I would say the aspect that the user sees. For example, the whole life cycle of consent. What am I consenting to, and so on and so forth. And then there is the whole backlinking that happens, which is a painful part, okay, so to say. So let me give you an example. Let's say as a company, I have 3 lines of businesses, okay. The first line of business, maybe as a user, someone comes to me and says that, hey, I'm okay with getting direct marketing from business line 1, but I may not even be aware that there is a business line 2 and a business line 3 as a user. So make sure that you get consent separately for each, right? Going back to what Nikhil said, you need to get granular consent. It cannot be bundled. It cannot, you cannot assume that just because as a user, someone has consented to getting direct mailers for one particular business means automatically for the rest. So let's go back to that 3 lines of business wala example. Now, let's say I get, I'm okay with receiving mailers for, let's say, business 1, but not for business 2 or business 3. There may be somebody else who comes saying, I'm okay with receiving mailers for 2 and 3, someone else for 3, etc. And then, there'll be different permutations and combinations. Now, all of this, look at where in the back end it is connected to. You may have 10 teams that are doing various aspects of, marketing. There may be 30 other vendors who are doing this. There may be, 10 apps that are applications internally that are using this. Make sure you do the mapping, because every time that, consent is changed, it's withdrawn, it's given, you should be able to backlink it everywhere, right? So those are some aspects I thought I should mention. Another quick word on taking off from what Nikhil mentioned, right? Remember, end of the day, for every purpose and a process, there has to be a lawful basis for processing. So it's like a triangle that you kind of face. So for what does that mean? So it means that if, for example, my purpose for collecting data may be for, let's say, providing a financial product, or maybe for responding to client queries, it means the purpose is that, which means that you can use probably a legitimate use. But I'm taking that same data, I'm using it for, let's say, advertising purposes. The purpose changes, so immediately the accompanying lawful basis changes. So here it may be consent for the same data for a different purpose, it may be something else. So make sure you do that mapping very clearly. I think that's, I'll take the rest amongst questions, but these were some initial thoughts I said I should.
So thanks a lot, Shivangi. Actually, I think that insight that comes in about the purpose changing, and that requires you to rethink about how the act is applying now. That's a very important shift in thinking that industry now has to think about with the new law coming in, right? There are quite a few questions that we've gotten from the chat that I think are really interesting and that we should be talking about. One conversation from Gitanjali that has received a lot of support for us to ask is that, let's say that we start collecting data for webinar signups, and we place our terms and conditions with a checkbox stating that we will also use it for newsletter and marketing emails. Can we do this, or do we have to stick to only webinar emails? So Shivangi, Nikhil, it would be great if we could get your response on this question. And Shivangi, maybe this would be a specific use case which we could unpack.
Nikhil, you'd like to go first?
Sorry, I even missed the question. Sorry, I just got.
Yeah, just gonna so Shivangi, if you'd like to take it, and then we can have Nikhil come in on the next one. Yeah.
I always advise people go back to the first principles, right? So in this case, what is the first principle? You have got consent, or a person has probably ticked for a specific purpose, which may be for attending a webinar, right? Now you want to use that data for another purpose, which is maybe to send mailers or advertising messages, etc. Because the purpose has changed, logically, you need to get a fresh consent. You cannot bundle it together, right? So I think this is not just this use case, but in any other use case, go back to the first principles. Check what is the purpose, check whether that purpose is the same for something else. If not, go back and see whether you need to get a fresh consent or any other legal basis.
So here, would it be okay to say that you can just have 3 check boxes and let the user then tick the ones they want to consent to, right? It could be in the same document, but 3 separate check boxes.
Yes, it could be like Nikhil mentioned, you cannot have pre-tick boxes. You have to unbundle, and I have to go and make sure that I check. So there's a use case that we use in all our training programs, which I'd like to mention specifically. So let's say I go to, let's say you come to me for a specific product, right? And I have to ship that product to you. I'm a retailer or something like that. So for that, I take your address. Now, as part of that entire communication, it's not gone, or there's been some challenge in delivery. All of that communication comes under that initial purpose of servicing you with a product. Now, I retain that, and 6 months later, I decide to use it to send you a mailer. That becomes a different purpose, right? So there are nuances to it, and we make sure that as long as you have this mapped out and you have a view, usually there's no confusion, because then the clarity emerges for you guys.
So I think that one key thing to keep in mind is that the Act actually says that you have to make sure that consent is recorded through a clear affirmative action. I think that's the big change here, and we'll be looking to see as we start hearing more from the rules, and then later on when the board starts hearing these cases, we'll get a lot more granular clarity. But the key shift in thinking is that we have to now start thinking about what are the best practices that industry can implement to ensure that they've recorded that clear affirmative action. This actually connects to a very another interesting question from the chat, that if we send a personal notice to the users that we have your data in our repository, and we would send you emails or newsletters which may be of your interest, and if you don't want to receive it, then please unsubscribe, or we give them a link to erase our data from our repository, does the Act support this? And if the person doesn't unsubscribe or doesn't actually ask us to erase the data, can you continue to send further marketing emails? I think that's a very important use case. And Nikhil, this would be great to have you come in and perhaps talk about this in the context of 5.2 specifically.
Yeah, so I think from a context of 5.2, which is, we need to go back and, give notice, right? And which sort of validates the fact that you've been doing or sending these marketing emails on the basis of the information that was provided before the Act came in place, right? Those instances, what we recommend is basically sending out emails to your clients or member base, and it applies to us also, saying that, look, you had given your data and we've been sending you emails, newsletters. Now, do you want to continue using this? If you don't want to continue, then you have the option to click the unsubscribe button, and we will no longer contact you. That sort of a provision should be enabled. And I think, look, I think from a marketing perspective is probably where it's more easier. But I would say we need to just look at it specifically on how the consent was taken in the previous instance. And as you know, There were several companies who were not relying on consent for marketing emails. They were relying on third-party data, information from other sources, which is something that we need to keep in mind. So the 5.2 says that this is only applicable if you have taken consent, right? So then the question is, if you hadn't taken consent, can you even go under that route to revalidate it? Or is it like a completely different fresh consent that you need to apply for? The jury is not out on that yet, but it's a complicated question that we need to look at closely, depending on where you got that data from. So clearly, if you got the data from a non-corrupted source, then I think we are fairly clear. If it's from a corrupted source, then of course there are a few things that we need to keep in mind. Either we should delete it, or do some other way to revalidate consent as a whole, and not necessarily a 5.2 process, a much more elaborate one, just like a 5.1 process, which is a fresh consent sort of an approach.
Yeah, so 5.1 and 5.2 are actually sections in the Act for those unfamiliar. We recommend that you go through them as well. They are about notice and how you give notices to individuals and customers for their consent. One interesting question, actually, Nikhil, because I think this has been asked many times in the chat, is that can organizations use purchased databases for marketing purposes? What are the obligations? So I think this is a question about if you buy a database for running a marketing campaign, does the Act actually prohibit that completely, or is that still possible under the Act? This would be a great question for us to just discuss. Yeah.
So there are, look, it's a very interesting question. I mean, it's not a very easy question to answer. For instance, if you purchase a database, it will really depend on where that database got its, source in the original place. Like I mentioned, I had, let's say, put my email out for the purpose that, clients can reach me out. And let's say a database captured that email and you reach out to me for that purpose. There is potential to argue that, look, it's not really personal information, right? But if I had not done that, and let's say my phone number is not listed anywhere, and then somebody is reaching out using that number, and then that forms part of a purchase database, and then you're using to market, it's arguably a violation. Now it's very difficult to determine this particular aspect by way of, it's not possible to even trace where all this data came from. So if it came from a corrupted data source, then there is a risk that you are carrying that the customer may get angry, right? May get pissed off, say that, look, violated the provisions of the Act. In those instances, what's the best possible scenario is to basically go and take a consent at some instance, right? Is potentially the best way to do it. So it's like I said, it's a fairly complex question. Also, the other thing to keep in mind is that, look, currently the Act says that any publicly available information is outside the ambit of the Act, which probably means that, look, my Gmail ID, which is not really public in that sense, you cannot contact me there. But my Trilegal ID is actually public, and you can contact me there for any sort of marketing purposes. And I just have to sort of, bear through that whole, messaging that comes to me, except the fact that you have to actually provide an unsubscribe option when you sort of do that, right? Because the voluntary provision is something which is also forming part of the publicly available information. So if you read that together, you should give an option to unsubscribe. So to answer your question, if you are sure of the source, right? If you are reasonably sure of the source that it's come from a public source, then I think you can use it with an unsubscribe option. But if you're not sure of the source and it's a corrupted source, then I think it's risky to go down that route.
No, I think that's a very important line for us to be thinking about. And one question that's also coming from the chat is that the entire option of withdrawing consent that's now in the law. And so can we speak a little bit about that? So I think is an unsubscribe button like that, but what are the other ways in which we need to help consumers get their rights to withdraw consent? Like what are the routes and mechanisms that companies can think about? For both of you, whoever wants to take it first.
Do you wanna go first?
Sure. In terms of mechanics of making that happen, it's a good idea to have like a privacy portal for organizations, which has, where you can manage your entire consent life cycle, you can manage rights and, provide a notice, stuff like that. It's all in one place. So that's from a mechanics point of view. But How you actually translate it in the back end is up to you in terms of how you're organized and stuff like that. That's purely from coming from an implementation angle, but Nikhil may want to add to that.
No, absolutely. I think this makes sense, Shivangi. So I think one is, of course, having a dashboard. Dashboard will give you the opportunity to withdraw consent and also a request for erasure of data, gives folks the right to access and correct the data that they want to do. So I think privacy dashboard is probably a easy use case. And that will largely ensure that most of the obligations are complied with. The other thing that we need to think of is, look, we should also make sure that we cannot engage in a dark pattern of making unsubscribe more difficult than subscribe, right? So that's something that we need to keep in mind. So at the email level itself, unsubscribe button is a must to my mind, right? But just for someone who's just signed up on marketing communication, we cannot take them through a 5-screen journey process to unsubscribe. That could be potentially challenged. And also keep in mind that, look, there is a new dark pattern regulation which is coming up that may also have a bearing on advertisers. That's under the CPA, which is a major topic in itself, standalone to discuss. So we cannot do that. The third thing is, I think there's going to be a lot of benefit from the new consent manager implementation once that comes out and we get clarity on how that works, right? A consent manager is going to play a very key role when it comes to withdrawal of consent, erasure requests, deletion requests, etc., etc. Consent manager is going to play a huge. So arguably, I'm hoping that for smaller companies, as mid to smaller companies, I think you will probably find a lot of consent dashboard as a package tool which could be exercised by them rather than building standalone tools in itself. And I'm sure, Shivangi, you will know more about how that industry has developed so far.
So just also on this, I think dashboards is one thing, but dashboards also kind of connect, and this is connecting to some of the questions in the chat. How would the rights of the data principals also help out here, right? So, for example, if I've given my consent before, what does the act allow a consumer to actually do then to figure out, how to exercise more control over consent that they've given and data that's being used for marketing? Shivangi, maybe you could talk a little bit about how the rights play out over here and what you need to be thinking about.
Yeah. So let's take a use case of, let's say you have given your consent, right? And for certain activities. And let's say you have withdrawn that consent after some time, or that consent, the purpose itself has played out, right? So let's say you gave your consent to for again buying a particular product and you finished receiving the product, so the whole purpose has played out. So either that, or when you withdraw consent for a purpose, the organization is expected to delete that data. However, I think there is yet clarity to emerge in terms of the time frame within which that data needs to be deleted, right? At that time, you as an individual, you have the power to go and exercise your right to erasure, in which case that data, if provided it is no longer required to serve the purpose or for any other laws and regulations that may come in, then the organization is expected to delete that data. So you can either exercise your right to delete data, you can exercise your right to even confirm whether that data exists. And in fact, from an organization's perspective, I think both these rights are a massive sort of, is going to require a lot of effort, because anybody can actually come up to you and say, hey, do you have my data? What are you doing with that data? Which third parties are you sharing it with, and what data are you sharing with third party? Now, to translate that right into reality means you need to really look at all that data and the data flows and maps and so on, right? But so essentially, as an individual, they can exercise their right over data in these manners. So either assume that the organization will do it as part of obligations, but you can sort of confirm by exercising a right. So it gives a lot of power to the individual.
I think Rights is definitely one part of it. So one question that's coming out from the chat, I think connects back to what Nikhil was talking about earlier, which is about the scraping of publicly available personal data, which we understand that database companies for marketing purposes do fairly frequently. Does the act actually say scraping is illegitimate or legitimate? Like Nikhil, you mentioned, how do you figure out as a company if the database is from a legitimate public source versus a compromised source? So these two questions about source and scraping, could we get a little bit more clarity on that?
Sure. It's a very interesting question, Varun. And look, this is something which has been debated worldwide from the perspective of even the whole large language learning models evolution and how scraping has sort of, done to contribute to that, right? So the act doesn't get into it, but the answer lies in the IT Act, right? The answer lies in the Information Technology Act 43, which talks about unauthorized access to a computer resource. So if there is a database which is making certain information available to public, and it has got a non-crawling, non-scraping sort of a position in their policies, including terms of use or terms of access use, or even if they have like robot.ttx files embedded into the whole code of the website itself, then an act of copying, either by way of direct copying. Sometimes it could be using robotic remote automation processes. Those sort of processes are amount to a violation of 43, and it's arguably a violation of 43. We don't have a case law on this yet. We don't have exact positions which is developed, but the plain text of 43 suggests that any unauthorized access, including accessing of website, is including scraping, is a problem. So first of all, you've scraped it, right? So that's an offense under IT Act. Then there is an obligation under Section 4, which says that you can only use it for lawful purposes. Basically, it's either legitimate use or this thing for a particular lawful purpose. So if you're using it illegally, and if there is a data which is acquired by way of what I call the color data is being acquired by way of a process, then that process could be delegitimized under the Data Protection Act as well, and it's potential to argue that look, there was no consent in the first place. And also the other thing that I mentioned to you about voluntary use also comes into play. A voluntary provision also comes into play. Voluntary provision is featuring in two places. One is for 7A, and other is for 7A, which talks about legitimate use. Second is it's also featuring in publicly available information use. So only those data which has been voluntarily provided by a data principal is allowed to be publicly scraped and used from the PDP context. So I think we should read it together, and the answer simply is that if you scrape data without getting the permission and use it, it may amount to a claim under the IT Act read with the DPDP Act. I don't know why I keep saying that.
I think everybody is still making the transition from a bill to an act for sure. And scraping is definitely going to be something that we're going to see much more interesting developments now that we have a data protection law as well. So just to clarify for the audience, there are two sections in the IT Act that most people know about. One is 43A, which is where the sensitive personal data rules of 2011 came out. So this act coming in means that section and those rules are no longer in force. They've been replaced by our new data protection law. But 43 is about unauthorized access, which is a separate provision and continues to be in force right now. So just wanted to keep that in mind. One question, I think.
Can I ask a question?
Yeah,
before? So see, the rules are not here, right? So Shivangi, maybe you can take this first. From a point of view of implementation, from an advertising and marketing perspective, from a cost and time perspective, have you thought of a couple of things which will actually change or which will take investments, or from a point of view of reorganizing a typical setup in terms of that, or what will take time? And also related to that, are there very specific things where you're hoping that you would get a little more clarity in the rules from an implementation perspective? It's a little broad question, but any insight from you, and I'll come to Nikhil on the same after that.
Yeah. Actually, I mean, I've been saying this in all forums. What clarity, there's so much to be done before you even look up the rules and understand the nuances. What I've seen over the last 8-9 years, most companies struggle to just finish their data mapping and keeping up with that. So you have to understand what's going on with personal data within your custody, what is going on with third parties, right? So what data is lying with which third party and so on. So that kind of mapping takes time. And until you have that mapping, until you have a understanding of what are the purposes you're currently using for, and then granularize them, right? It takes time because it's not an overnight decision. This impacts businesses. It impacts the way you're doing, the way you're running your campaigns today, the way you're, reaching out to customers today. There's a lot of internal debating that goes on. Sometimes decisions don't get taken for a couple of quarters or more because there is so much of backing and forthing happening on it, right? So some of these things are important to do. Third, so if I were to summarize, I would say look at mapping your data. And I'm not talking about data discovery and that detailed sort of thing that takes time anyway. I mean, a lot of companies have been, I know, have been at it for 2 years, 3 years kind of thing. Just a high level map, right? Do that. Look at specifically what's going on with apps, what's going on with your digital properties. Look at what's going on with third parties. So there are nuances we talk about, right? So I know that there was a question around outsourcing to third parties for some of the marketing activities that you do. Now, as long as the third party is doing it only for the purposes of third party is doing exactly what you ask them to do, then in which case they are a processor. But the reality is that many third parties use that data for their own purposes. They do their own analytics on it. Now, if that is happening, that makes them a fiduciary as well. So it changes the way the equation is between the two entities. That means you go back to re-looking at your contracts, re-looking at what are the other measures you put in place to make sure that they're doing only what they're supposed to do. So otherwise, the liability comes back on you. So that is one thing. Looking at your entire third-party risk management is another activity that one needs to focus on. And once you have that map, then there is a lot that you can do with the clarity emerging from the rules and regulations.
All right, thanks. So I think there is so much to do before you get into rules. So Nikhil, if I turn to you and say that, what is it that you don't have to worry about right now, and the work will start only when you get to the rules when it comes to advertising and marketing? Are there 2-3 things which we shouldn't bother right now, let the rules come?
So look, I think I mean, you can definitely have a peaceful sleep at night. I mean, that's something that you should definitely not worry about, right? So look, I agree with Shivangi here. I think it's time to start thinking about it, because we don't know what the compliance window is going to be. I'm assuming there will be reasonable time, and that's what even the minister has said. But I think we should start thinking about it, figuring out where we are in terms of our inventory, figuring out what are the various processing activities that we do. And if there are low-hanging fruit, like for instance, we don't need to really wait for the rules to come out for implementing a 7A simple marketing tool and those sort of activities. Those are all low-hanging fruits. I'm saying low-hanging because of this. I'm not saying it's not an effort. It is an effort. There is a cost, but it is not such a big effort compared to for instance, a full detail mapping, right? So at least you have opportunities to even say that, look, there is data that I've collected before the act. I'm just gonna probably keep and store it in a different place and have a different ways to sort of track them and create an inventory process which will happen. But there is ongoing new collection that's happening. Let me just implement a new mechanism which will going forward apply to everything under the act. That is something that we can start thinking about, and by the time the act comes in force, we can probably achieve compliance, right? The other thing that we need to keep in mind is, look, the 1-year period of time, let's assume we get it, it's going to give us this comfort of ensuring and playing with some of these options and coming out with best option that works. It also gives us, hopefully will give us a compliance window for any sort of breach or arguments. But we don't know where it's going to stop, right? So whatever smaller things we can do right now, let's start thinking about is the way that I would look at it.
So I think we're actually almost close to the time running out. I think one last question would be that this is a question that we received multiple times about just retention and thinking about retention. So how should companies keep track of retention right now? And maybe it's also an opportunity for us to just think about how do we keep track of purposes themselves. So Shivangi, any practical kind of steps to just do that kind of tracking internally that you can offer? You mentioned mapping, but what would be something that would be a practical step that industry could do?
Yeah, so we do this with wherever we implement. Start building what we call a purpose repository. Okay, make it as granular as possible. It will, over a period of time, it will run into several purposes. It helps you in automation later, right? Standardize, use the standard terminology, and start mapping that. This itself is a huge step forward, and it's a good initiative to have. Different businesses can have that. That's one thing I can say. And do a high level, we call it PDAM in our world, attribute mapping. Look at channels for inbound, outbound data. Look at, where the third parties. It doesn't have to be a complete list of third parties, but just understand. For example, you may have 10 SMS vendors, but the fact that you have an SMS vendor, you need to identify, types of vendors you use and so on. And consent backlinking. It takes a while, but again, do it, because sometime you have to do it.
Great. So thanks. I think this has been a great session, and we've got just about a minute left in time. So just going to take that to double click on what Priyanshi just dropped in the chat box. We are planning more sessions. I saw many questions just come out on what to do and how the act applies to employee data. We'll be doing a dedicated session on that. We're also seeing some questions come out on what do I have to do if I'm a global capability center and I don't actually have customers in India, I'm serving a foreign client. So we'll also be doing a dedicated session on that. So please do stay in, please do register for those sessions. You should receive the link by today for registration. And with that, I just want to close. So Shivangi, Nikhil, thank you so much for joining us today. I think this has been really, really useful. We've received so many requests for Nikhil for your presentation to be shared. So please do share that to us so that we can share it to interested members that have joined in. And thank you so much for staying. We received, there were 190 people on the call and they've remained consistently throughout the entire call. So it's great to see so much interest, and we're still in the early days of implementation, but clearly many, many practical and interesting questions to think about. With that, I think I'll like to close, and just a friendly reminder to everyone, this will be available later on as a recording on social media for you to review and for you to go through Shivangi and Nikhil's really useful insights again slowly, or maybe at 0.5x, so that we can track out everything that we've said in this huge dump of information that we have to go through today. So thank you so much for joining. Thank you, Shivangi, Nikhil, and see you guys in upcoming sessions.
Thanks, my pleasure.
Thank you so much. Bye-bye.
Thank you.